Hello and welcome to this video course on how to ensure compliance with the General Data Protection Regulation, or GDPR for short, in private practice. My name is Ellie McDonald and I work at WriteUpp. We're a practice management software company and we help clinicians take their businesses online. We work with thousands of clinicians across the UK and Europe, and one of the top 3 concerns with them is how to correctly comply with GDPR. Ensuring that your practice is up to speed with GDPR is essential, not only to protect your patient's data, but also to protect yourself from fines, penalties, and of course, reputational damage as well. Whether you're considering going into private practice for the first time or you are an experienced practitioner, this course is designed to explain GDPR in straightforward terms. In the next 4 modules, you will explore how GDPR works and how it can be applied in your practice. The main objectives that we want to achieve on this course are, firstly, to cover the fundamentals of GDPR, including key concepts, principles, and data protection roles. We're going to examine the key rights protected by GDPR and their relevance in private practice. We're also going to understand the differences between data controllers and data processors. And finally, to help you navigate the legalese often associated with GDPR in an easy to understand and really relatable way. By the end of the course, you should feel at ease with GDPR and will be able to handle different contexts of its application as well. We really hope you'll find this course interesting and also really engaging. This course is CPD certified, so you'll be able to log your CPD points once you've completed the final module. As way of a caveat, this course does not constitute legal advice. If you have any specific questions about GDPR, privacy, or data protection, then you should speak to a lawyer or a solicitor specialising in this field. Let's get started. Welcome to Module 1. In this first module, you'll learn about the basics of GDPR. This is a crucial step for achieving a high level of understanding of the regulation and its impact on the data protection landscape in the UK and the EU. We're going to be looking at the importance of GDPR, what your responsibilities are, privacy and data protection, the 7 data protection principles, and finally, the position of minors and the issue of consent. Before we dive into the details about GDPR and cut through the complexity of what it entails, I would like to ask you to answer 3 rather general questions. Why is it important for you to know about GDPR? What do you know already about it? And why and how does it specifically apply to you? Pause the video now and take a few notes in answer to those questions. We'll come back to your answers to compare what you know now and what you'll know by the end of the course. GDPR is an EU regulation that guarantees individuals' rights when their personal data is processed. It applies to any organisation that collects data about people in the UK and the EU. UK GDPR took effect in the Data Protection Act 2018 as a result of the UK's departure from the European Union following Brexit. At the time of recording, the key principles, rights and obligations are exactly the same. From here on in, we'll refer to the legislation simply as GDPR. GDPR is a collective responsibility shared between the data controller, that's you, the clinician or practice, and the data processor, if you have one, such as your practice management system provider. Jointly, you are responsible for protecting the rights of the data subject, your client or patient. As the name suggests, you, as the controller, determine what you do with the personal data that you collect and how it's processed. If you use a cloud-based practice management system, they are your processor, and their responsibility is to protect the data and provide the processing required by you as the controller. We'll go through this in more detail later on in the course, so don't worry about the differences right now. So what are privacy and data protection? Privacy and data protection are fundamental rights protected by UK law. Privacy refers to the part of our lives which we as individuals want to control and keep to ourselves. We live in a globalised and technologically dense world. We constantly interact with others, communicate using various devices, and store on them information about our clients and ourselves. In society where information and communication technology is being increasingly used, data collection and processing has become an important factor and a way of life. The right to data protection has therefore been developed to protect individuals from potential harm due to data abuse or misuse. In GDPR, the right to data protection is covered by Article 8 of the Charter. Everyone has the right to protection of personal data. UK GDPR is centred around 7 principles. These principles should lie at the heart of your approach to processing personal data. They don't outline hard and fast rules, but rather embody the spirit of GDPR in a manageable list. Compliance with the spirit of these principles is a fundamental building block for good data protection practice. The first principle concerns lawfulness, fairness, and transparency. Any information and communication concerning the processing of personal data must be easy for your clients to access and easy for them to understand. They should be able to access your data policies on your website, or you should send them by email when an appointment is made, for example. The second principle is of purpose limitation. So personal data should only be collected for specified, explicit, and legitimate purposes. And these purposes should be laid out in your data policy. You must inform your clients about the purpose of the data collected and only use the data for those specific purposes. Clients must also consent to the use of their personal data and must be able to easily withdraw consent whenever they want to. The third principle is data minimization. Personal data must be adequate, relevant, and limited to what is necessary. This means that you should only store the minimum amount of data required. Don't collect information such as national insurance number, for example, if you have no need for it at all in your practice. Accuracy is the fourth principle. Personal data must be accurate and kept up to date. It's important that old data is securely disposed of in line with your privacy policy. Keep on top of your data, regularly review information held about patients, and delete or amend inaccurate information. The fifth principle is storage limitation. So once you no longer need personal data, it should be deleted or completely destroyed. Within your profession, you will be required to keep patient records for a certain number of years before they must be deleted. Just make sure you know what the retention period is within your specific profession and set this out in your policy. Integrity and confidentiality. So for this principle, you must ensure that all the appropriate measures are in place to secure the personal data that you hold. This could be protection from internal threats, such as unauthorized use, and a way to protect yourself from this would be to make sure that everyone who has access to the data in your practice has their own login to the secure system that you use, and that they have the correct access rights applied to their account as well. The final principle, accountability, means that you must take responsibility for the data that you hold. And also you have to demonstrate compliance with the previous principles. It's really not as tricky as it sounds, and I know it does sound hard. You can do this through the documentation of all your policies and processes. That can either be in your practice management system or in a Word document that is accessible to everybody within your practice. The processing of personal data is only lawful if patients give their consent. Consent should be obvious, concise, easy to understand, and user-friendly. And it also requires a positive action to opt in. There's a few ways you can go about this. Your practice management software should have a built-in consent portal, which will allow you to send consent forms out by email to your clients for them to opt in online before their appointment. Their response will then be saved to their record. You can create a paper form for them to read and sign when they come into clinic, and you'll need to then store these securely in a filing cabinet on site. Patients may also withdraw their consent at any time, so do make it easy for them to do this. Article 8 specifically deals with the issue of providing consent in children. The processing of personal data of a child is lawful if the child is at least 18 years old, but the age of consent can vary by speciality and circumstance. For example, for preventative or counselling services, this is one example. You can check it out with a professional body or your lawyer. If a child is younger than the age of consent, the processing is only lawful when consent is given by the parent or legal guardian of the child. It is your responsibility to verify that consent is given by the parent or legal guardian. You should be able to prove this too. Welcome to Module 2. In this module, we are going to take a deeper look at some of the rights of data subjects, such as the right to rectification and the right to erasure. There are 8 key rights protected by GDPR that are essential to know. The right to be informed, the right to access, the right to rectification, the right to erasure, the right to restrict processing, the right to data portability, the right to object, the right to not be subject to automated decision-making. In short, any personal information you hold about your clients or patients must be easy to read, easy to access, and easy for them to consent or not. We'll be going through these in more detail shortly. You as the data controller need to take certain actions to ensure the rights of your clients. These are the so-called transparency and modality requirements that can be found in Article 12 of GDPR. Modalities are the different methods that are used to enable your clients to exercise their rights under GDPR. Things like how they are informed of your data policy, how they request a copy of their information, or how they can rectify any errors in their data. Remain transparent by providing information relating to the processing of personal data in a concise, easy to read, and easily accessible format. Give them this information at the time of their personal data is collected in an online form or when they ask for the right to access. The right to be informed means that your clients have the right to know how their personal information is collected and used. You need to tell clients who you are, why you need their personal data, how you will use it within your practice, how they can modify it, how they can access it, how they can retract consent to hold and process their records, and how they can raise a complaint should they wish to do so. The information you provide to clients must be concise, transparent, intelligible, easily accessible, and it must use clear and plain language. Getting the right to be informed correct can help you to comply with other aspects of GDPR and build trust with people. Getting it wrong can potentially leave you open to fines and lead to reputational damage. Your clients have the right to access and receive a copy of their personal data. This is commonly referred to as a subject access request. You need to provide your clients with access to their personal data if they request it and explain in clear, non-technical terms how you are processing their data and how long you will be keeping hold of it as well. Individuals can make an access request verbally or in writing, including via social media, so just bear that in mind. A third party can also make an access request on behalf of another person. You should respond as soon as you can, but within 1 month of receiving the request. GDPR also includes a right for your clients to have any inaccuracies in their personal data rectified or completed if it is incomplete. If you shared their information with a third party, like their GP, for example, you will need to notify them of the amendments too. Right to object and right to restriction of processing. So under Article 21, your clients will have the right to object to you using their personal data for any reason at any time. You need to let your clients know in your policy that they have the right to object to their data being used. Clients also have the right to request the restriction of their personal data under Article 18. This is not an absolute right and it only applies in certain circumstances. For example, if they contest the accuracy of their data and you are verifying it. When this right has been exercised, you'll need to prevent any further processing of the client's record going forwards or until they re-grant you the right to process their data. Your clients have the right to erasure, to have their personal data completely deleted. This is also known as the right to be forgotten. The right only applies to data held at the time the request is received. The right to data portability allows your clients to obtain and reuse their personal data for their own purposes across different services. Basically, this means that they can move, copy, or transfer personal data easily from one software provider to another in a safe and secure way without affecting its usability. The right to not be subject to an automated decision-making in Article 22 is relevant if you provide certain types of data to health insurers. Individuals have the right not to be subject to a decision when it's based on automated processing and it produces an adverse legal effect or significantly affects the individual. Your clients have the right not to have judgments made about them based on algorithmic decision making. Welcome to Module 3. In this module, we'll look at who data controllers and processors are and what their roles and obligations are under the GDPR. So who are data controllers and data processors and what are their obligations? So Article 4 of GDPR determines who controllers and processors are. Controllers are those who determine the purposes and means of processing personal data. And processors are those engaged in processing personal data on behalf of controllers. So you, as a practice owner, are the controller because you determine the purposes and the means. If you store your data with a software company, they are the external party who process the data on behalf of you and under your instructions and are therefore the processors in this process. Keep in mind that you may have other processors over and above your practice management system provider, and you may need to have an explicit data processing agreement, or a DPA for short, in place with them if your relationship with them isn't defined in their terms of service and or the privacy policy. Data controllers control the processing of data, determine how it's used and where it's kept. To comply with GDPR, you have to take appropriate measures to protect your client's data and their rights. You need to demonstrate that you have measures in place to ensure data protection by design, so built-in technical safeguards, and by default, processing only personal data which are necessary for a specific purpose. But what does that mean for you and your practice in a real-world setting? Well, let's break it down. You need to maintain records of all processing activities. You can use a practice management software, which will record all your data processing activities for you, including obtaining consent. You also need to ensure a high level of security. So keep data secure by using practice management software. Strong passwords prevent loss or theft, and as soon as a device is lost, access can be easily revoked, providing complete and total protection. So it's really, really secure and a really great way to secure your data. Copies of paper documents can get into the wrong hands, often by accident, and are not considered as secure. You need to notify the supervisory authorities in the event of a data breach. Consider whether the breach poses a risk to people. Was anyone identified in the breach, and was this information personal to them? If it does, and if it was, you must report it to the ICO no later than 72 hours after becoming aware of the breach. You don't need to report every breach to the ICO. They have a self-assessment tool which will help you decide what needs to be reported or not. Sometimes you might need to conduct a data protection impact assessment. It's unlikely that you'll need to do this, but if you have a major project that involves the use of personal data, it is good practice to do a DPIA. You can use the DPIA template from the ICO. You need to cooperate and consult with supervisory authorities as well. A supervisory authority is an independent public authority that is responsible for monitoring compliance with GDPR. And in the UK, that authority is the ICO. If you have carried out a DPIA that identifies a high risk and you cannot do anything to reduce it, prior consultation with the ICO is required under UK GDPR. You need to assist data subjects with exercising their rights to privacy and data protection. So your clients will need to have an easy way to provide consent and to withdraw it. You'll also need to provide them with an easy to read copy of your data processing policy. Compliance implies a level of accreditation that just doesn't exist. No one is certified against GDPR. Whether you're a data controller or data processor, it's your responsibility to comply with the regulation based on your interpretation of the regulations, how the regulations apply to your specific business, your assessment of the risks associated with recording and processing personal data. If you, as a data controller, want some kind of assurance about your data processor, take a look at the relevant international standards. There are a number that touch on or relate to GDPR, but your starting point should always be the ISO 27001. Here's the official definition from the ISO, the International Standards Organization. So ISO IEC 27001 2013 specifies the requirements for establishing, implementing, maintaining, and continually improving an information security management system within the context of the organization. It also includes requirements for the assessment and treatment of the information security risks tailored to the needs of the organization. The requirements set out in ISO IEC are generic and are intended to be applicable to all organizations, regardless of type, size, or nature. Given the standard scope and the fact that it requires ongoing auditing and certification, it provides you as a data controller with a really good measure of a processor's ability to protect the integrity of your data. So how do controllers demonstrate that they're complying with GDPR? Well, this will vary by industry, so do check what you need to have documented to be able to prove compliance if you're audited. Some examples of the evidence you could use are the documentation of privacy policies and processes. So if you share data with anyone for safeguarding, perform subject access requests, or you delete data for necessary reasons, you should have policies in place that highlight how you do this. You can keep these on your website or as a local file on your computer that everybody can access. Keeping records of all data processing activities is another way that you can do this. Your practice management software will do this for you. At the end of the course, you'll be able to download our GDPR checklist, which will cover the key compliance areas. The next module is your 12-step guide on how to ensure you are GDPR compliant in private practice. Hi, welcome to Module 4. Both the ICO, that's the Information Commissioner's Office in the UK, and the Data Protection Commissioner in Ireland have produced a step-by-step guide to help you with GDPR. We'll now go through the 12-step process mapped out by the ICO and the DPC. Step 1 is awareness. If you've not already, you should make sure your team is aware of GDPR and the broad principles involved. Maintain a steady flow of GDPR information to your team. Commit resources and budget to GDPR, and make time to understand the regulation and documentation of risks and processes. Make time for training, education, awareness if you have multiple team members, and budget for any legal drafting of policies. For step 2, accountability, you need to know what personal data you hold. So if you've previously made the decision to put your client-related data into a cloud-based practice management system, then it should be really, really easy to identify what personal information you hold. If you've taken a more fragmented or paper-based approach, you might find this step challenging. A fragmented approach might be something like an Excel spreadsheet with client details stored on Dropbox, or Word documents stored locally on your hard drive with notes on them, and perhaps some paper records of assessments, or even a handwritten list of client-related tasks. Where it came from. So as well as knowing what information you hold, you'll need to identify where it came from, and going forward, you will need to capture the source of each record that you add to the system. Something along the lines of walk-in, web inquiry, clinical referral should be suitable, along with a date and timestamp confirming when the record was created. Next is who you shared it with. For many, this could be the biggest challenge, as you will need to keep a record of what and who you shared your data with. Again, in a clinic management system, this is pretty straightforward, as all your outbound communications by email or text message will be stored in there. Maintaining this log will service a couple of purposes amongst others. Firstly, it allows you to keep track of where you've sent your client's data. It allows you to notify the relevant parties that you've shared the data with if your client asks for a change to their record, for example. Step 3 is communication. Ensure you've done the necessary housekeeping and you've updated your privacy statement to reflect the requirements of GDPR. Make sure that your clients are aware of key information like the name of your company as registered with Companies House or your local equivalent, the registered address of your practice, where they can raise a complaint if they wish to do so. This will be the relevant lead authority in your geographical area. For example, in the UK, it will be the ICO, as I've already mentioned, and in Ireland, again, it will be the Data Protection Commissioner. Other matters covered in later steps, like your legal basis to record a patient's personal data and retention periods, may require legal advice, so do seek this out if necessary. Step 4 is personal privacy rights. GDPR is a fundamental set of rights that you should review and thoroughly understand. Put together an action plan to ensure you comply with each of the key rights mentioned in Module 2. Doing it this way will make the job less daunting and help to avoid any omissions. Step 5 looks at access requests. In the event that you receive an access request, you will need to have the internal processes in place to ensure your staff recognise it and act upon it immediately. Record the access request with a time or date stamp in your practice management system or log. Securely provide the information in an easy to read and accessible way to your client free of charge within 30 days. Easy to read and accessible is important here. Handwritten notes that aren't legible will not be allowed. You should ensure that everything is typed up and sent to the client in a way that they can access, and that's usually by email. Step 6 is your legal basis. You might be able to put together an acceptable privacy statement that covers the key aspects of GDPR, but we advise speaking to your lawyer, or better still, a lawyer that specialises in data protection, and get professional assistance with this. Amongst other things, it will need to include your legal basis for processing your client's personal information, details on how long you'll keep their data for, and the retention periods of your records, and manage them accordingly. Many clinicians are familiar with the concept of clinical consent. However, consent in the context of GDPR relates to gaining your client's agreement for you to store and process their personal information. When you gain consent, you will need to do 2 things. First, keep a record of when and how you got consent from the individual. And secondly, to keep a record of exactly what your client was told when they granted consent. As part of any initial assessment, most clinicians dealing with children will record the child's age. Article 8 specifically deals with the issue of providing consent and children. The processing of personal data of a child can be lawful if the child is at least 18 years old. If a child is younger than 18, the processing can be considered lawful only when consent is given and authorised by the parent or legal guardian of the child. It is the responsibility of you, the data controller, to verify that consent is given or is authorised by the parent or legal guardian. You should be able to prove this too. GDPR places multiple responsibilities on both the data controller and processor in relation to data breaches. These include measures to detect possible breaches, reporting a breach to the ICO and or the individual impacted, depending on the nature of the breach, and investigating the cause of any breach. From your perspective, breaches are likely to occur as a result of human intervention. To avoid this from happening, there are some simple measures that you must put in place, such as ensuring that all users have unique logins to any software you use, enabling two-factor authentication, and that is a code that's sent to the user's phone after they've entered their login information as an extra security step. And both of these measures will ensure that any malicious actions will leave an audit trail that can be used to help with detection, reporting, and investigation. You don't need to report every breach to the ICO. They have a self-assessment tool which will help you decide what needs to be reported or not. Consider whether the breach poses a risk to people. Was anyone identified in the breach, and was this information personal to them? If it was, you must report it to the ICO no later than 72 hours after becoming aware of it. For extra peace of mind, you may wish to consider GDPR insurance offered by providers like Superscript. Data processors, like practice management software, will have measures in place to detect system-based data breaches, and you'll be notified in accordance with their contractual obligations if a breach occurs. You are legally required to design in privacy. Whilst this might sound slightly daunting, it makes absolute sense in the context of the rest of the regulation. You're required to put in place appropriate technical and organisational measures to implement the data protection principles effectively and safeguard individual rights. This is data protection by design and by default. Every future action, initiative, or project which impinges on personal data should be carefully considered with a clear eye on privacy. If you have a major project that involves the use of personal data, it is good practice to do a data protection impact assessment, as we mentioned earlier, a DPIA. You can use the DPIA template from the ICO, which will be included in the course resources. Although GDPR doesn't oblige every business to employ a data protection officer, it's good practice for someone in your organisation to firstly have the requisite knowledge about GDPR, to be responsible for complying with GDPR, ensuring that data protection is designed into your business planning, processes and changes, and evolving, maturing and improving how you comply with GDPR across your business. If your organisation operates in multiple countries, you should map out where your organisation makes its most significant decisions about its processing activities. This should help you to determine your main establishment and therefore your lead supervisory authority. For example, if you primarily operate in the UK, your lead supervisory authority would be ICO, and this is where your clients would go if they wanted to lodge a complaint or if you needed to report a data breach. At the beginning of this course, you noted down the reasons why learning about the General Data Protection Regulation was important to you. I'd now like you to reflect on the first steps you'll take in complying with GDPR. Okay, I know GDPR may seem daunting, but it can be kept on top of if you apply some effort to research and understand the regulation. Apply some common sense. Think of the regulation in terms of the protections that you would want and expect for yourself and your family. The main thing to remember is that data is personal if it can be related to an individual. Congratulations, you've reached the last step on the GDPR course. We have covered a variety of topics from basic GDPR concepts to processing principles, rights of data subjects, obligations for controllers and processors, and the ways in which you can ensure compliance. We believe after following our course, you will have a good idea of what GDPR is about, how this regulation may influence your life and business, how you can use it to protect your personal data, and how you may need to adapt your processing operations and practices so that you can avoid any future hassle. I really hope that you have enjoyed our take on GDPR. In a relatively short course like this, it's impossible to cover the content of the legislation in detail or to go through all the related GDPR provisions. So I would urge you to seek out full guidance if you need to. Many thanks for joining our course and good luck with implementing GDPR in your business.